Welcome everyone. My name is Brian Kitts. I'm the editor-in-chief for volume 39 of the Tulane Maritime Law Journal. I would like to thank everyone for attending this installment of the article presentation series co-hosted by the Admiralty and Maritime Law Committee of the ABA's Tort, Trial, and Insurance Practice Section and the Tulane Maritime Law Journal. Before we get started, I would like to acknowledge a few people who are here today. To Ray Wade, with your help, we started this program more than a year ago, and through your continued assistance and your generous time commitment, the program has developed into the well-attended and well-regarded event that it is today. Ray, thank you for everything you've done to get this program up and running. To the Tulane faculty and administration, particularly Professor Davis, who is here today, it's because of your support and backing that the Tulane Maritime Law Journal has become so much more than simply an academic journal. It is your support and this type of support that allows us to hold events like this. To the presenters, I was very impressed with each of your case notes, and each of you should be very proud about what you've written. We're all looking forward to hearing what you have to say. Finally, I would ask that everyone hold their applause until after each presenter has finished his or her presentation. Also, please reserve any questions that you have for the speakers until the reception following. Without further ado, it is my pleasure to introduce the first speaker, Ms. Taylor Coley.
Good evening, everyone. As Brian mentioned, my name is Taylor Coley. I am a 2L and junior member of the Tulane Maritime Law Journal. My case note is on Indemnity Insurance Company of North America versus W&T Offshore. I chose this case due to my personal interest in the offshore energy industry. And as you'll all soon hear, this case really turned on the Fifth Circuit's refusal to recognize the Underwriters' policies as excess rather than umbrella policies. First, I'll go over a few facts of the case. Hurricane Ike swept through the Gulf of Mexico in September of 2008, leaving behind more than $150 million in damage to more than 150 offshore platforms in which W&T had a commercial interest. In preparation for just such a storm, W&T had purchased 3 types of insurance. First, their commercial general liability policy, or their primary policy. Second, their 5 energy policies, or their energy package. And third, the policies in interest here, Underwriters' excess liabilities policies. Whereas the energy package covered claims regarding property damage, operators' extra expenses, or OEE, and removal of debris, or ROD damages. Underwriters' policy only allowed recovery for ROD expenses. After ascertaining that W&T had sustained over $150 million in OEE and property damages alone, their loss adjuster forecasted that they would exhaust their energy package and self-insured retention of $10 million and submit over $50 million in ROD claims to Underwriters' policies. The 4 underwriters of the excess policies filed suits seeking declaratory judgment that W&T's claims for ROD damages were not covered under their policies because their retained limit, or their triggering mechanism for their policies, had not yet been met. The court below granted Underwriters' motion for summary judgment and found that the excess policies could only be triggered by exhaustion of underlying policies that covered the same types of claims. W&T appealed, and after a de novo review of the contract, the Fifth Circuit held that on the plain language of the contract, W&T could meet the retained limit by exhausting its underlying policies with any claims, and that the underwriters were obligated to pay W&T's ROD claims. First, I'll discuss some relevant background on the relevant marine insurance policies here. Marine insurance for offshore energy companies can be described as a Tetris-like regime, consisting of various layers of horizontal coverage interspersed with vertical coverage policies. Sitting above and sometimes beside primary liability policies are so-called other insurance policies, including excess policies or umbrella or bumbershoot policies. These policies are not always clearly defined and are only recognized as other by their reference to underlying existing primary policies. The clauses within these policies are intended to limit the underwriter's claims to exposure. Thus, their content and phrasing is often uncoordinated and purposely varied across an insured's various policies. Excess insurance can be described as the vertical aspect of an insurance package because it rests on top of an underlying policy, providing virtually the same type of coverage, just at higher thresholds. The bumbershoot or umbrella policy fills in gaps within the insured's underlying layers of coverage. Sometimes such policies will include a drop-down provision that will typically provide coverage when underlying policies are either exhausted or otherwise unavailable to pay claims, such as in the case of insolvency. In addition to increasing the vertical amount of coverage, umbrella policies can also horizontally broaden the insured's primary coverage. Umbrella policies effectively shift away from the insured the burden of choosing which risks to which they will remain exposed. In the noted case, underwriters argue that their limits of insurance section, or Section 3D as I'll call it, prove that their liability could only be triggered by exhaustion of underlying policies with claims covered by their policy. The Fifth Circuit disagreed and held that the policies in question were umbrella and not excess policies, and used Texas law to construe that the plain meaning of the retained limit and limits of insurance provisions provided coverage to W&T in 4 separate scenarios, including paying for covered claims after underlying policies were exhausted by claims their policies did not cover. First, the court looked at the plain language of the agreement's coverage and retained limit provisions and found that their lack of limiting language did not specify how the retained limit must be met. Second, the court analyzed the text of Section 3D and determined that it outlined 2 scenarios where underwriters would assume additional obligations in the event that the underlying policies were exhausted by claims covered by underwriters' policies. Third and finally, the court distinguished Section 3D from a similar provision in a similar case, but that policy was held to be an excess policy, in Westchester Fire Insurance Company versus Stewart and Stevenson Services, Inc. Because the provision in this case, unlike the provision in Westchester, contained no expressly limiting language. I'll read you both the insurance provision at hand in Westchester and the one in W&T's policy so that you can note the difference in the no expressly limiting languages. Westchester's policy reads, in the event of reduction or exhaustion of the underlying insurance by reason of payment of losses not covered by this policy, etc. The policies here read, if the applicable limits of insurance of the policies listed in the underlying insurance or of other insurance providing coverage to the insured are reduced or exhausted by payment of one or more claims that would be insured by our policy. Essentially, the limiting language that they found in Westchester and not in W&T's policies are not covered by this policy. The court's finding here that underwriters' policies acted as umbrella instead of true excess policies is a results-oriented decision that runs in the face of insurance law interpretation and has problematic but not unique implications for future marine insurance cases. In construing the underwriters' policies, the court makes assertions of varying degrees of attenuation while failing to acknowledge that, at the very least, underwriters' interpretation is a reasonable one in light of industry custom. In the endeavor of following a plain text interpretation, the court manages to interpret text into the agreement that plainly is not there. The court essentially treats Section 3D of the agreement as a drop-down provision which would widen the breadth of W&T's primary coverage and describe scenarios in which they will assume additional obligations. However, there is nothing in any provision of this policy that states that underwriters will literally drop down to provide coverage, as is common in umbrella policies. Instead, the contract explicitly states that underwriters will pay sums in excess. Additionally, the court's reading of the policy ignores the term applicable limits of the underlying policies, which clearly suggests that there are limits in the policy that are not applicable to the underwriter's coverage. The court here criticizes underwriters for attempting to rely on Section 3D because it contains no limiting language. Yet Section 3 itself is titled Limits of Insurance. Further, as the section falls within the limiting portion, a harmonious reading of the contract would not logically show the section to contain a provision that widens the breadth of coverage. Finally, the court's decision here can be seen as willful ignorance of a practical fact. The policy here acts as a true excess policy. It allows for ROD recovery, which W&T's primary policy and energy package both allow recovery for. Umbrella policies traditionally broaden coverage. Contrastingly here, underwriters' policies fill in no gaps in W&T's coverage. In sum, this semantic scrutiny of language in insurance contracts inevitably leads to inconsistency in the field of marine insurance. By holding that an insurance contract, which facially resembles countless other excess policies, instead clearly denotes 4 scenarios of obligations and duties, and 2 of which the underwriters assumed additional, even more expensive obligations, the Fifth Circuit's decision here simply reminds underwriters everywhere of the risks involved and offshore oil and gas insurance, both those that underwriters assume to undertake and those that they may be judicially forced to accept. Thank you.
Good evening. My name is Matt Drenan. I'm an LLM and Admiralty candidate at Tulane and also a member of the Tulane Maritime Law Journal. I wrote on a case out of the Ninth Circuit entitled Kealoha v. Director, Office of Workers' Compensation Programs. I chose this case because of the unique issue it involves regarding Section 903C, or the suicide provision of the LHWCA, which precludes recovery when an injury is spawned by willful intent. Like many LHWCA cases, this case starts with a tragic set of events. William Kealoha's life changed forever when he fell 25 to 50 feet from a barge onto a dry dock, the first of several tragic events which would ultimately leave him physically and mentally crippled. Subsequently, just 2 years later, Kealoha would attempt suicide, shooting himself in the head with a shotgun and unsurprisingly causing severe craniofacial injuries. Kealoha offered testimony of an expert psychiatrist who, in addition to his physical injuries, diagnosed him with post-traumatic stress disorder, or PTSD. On appeal, the Ninth Circuit reversed and remanded the ALJ's decision, allowing Kealoha to recover despite the seemingly willful intent, relating his gunshot injuries back to his original work-related injury for Leeward Marine. I will not belabor the general background of the LHWCA, as I'm sure most of you here are familiar with the status and situs requirements under the 1972 amendments, as well as the general remedial no-fault framework of the LHWCA. I will, however, spend a bit of time speaking about 903C and the subsequent case law, as I think it's probably a bit foreign to all of us. Section 903C precludes compensation statutorily when the injury was occasioned by the willful intent of the employee to injure or kill himself or another. While only 2 federal courts have ever spoken on Section 903C, many state courts have examined the suicide provisions of their own workers' compensation statutes, but predominantly in non-maritime contexts. These cases have seen the emergence of 2 analytical standards: the chain of causation test, or approximate cause analysis, and the irresistible impulse standard. The first, the chain of causation test, looks for a direct and unbroken chain of causation, where the original injury resulted in a disturbance of the mind and caused the employee to attempt suicide. Under the Kealoha facts, this would involve an unattenuated chain relating the suicide attempt back to the original work-related injury with PTSD as the cause. The second is the irresistible impulse test, which is more of a medical standard, which involves the decedent taking his or her life through an uncontrollable impulse or through a delirium or frenzy. This would involve a medical analysis where the actual medical or psychiatric state of the decedent or attempted decedent at the time of his or her suicide or attempted suicide was actually incapable of developing the willfulness to attempt suicide. The first federal court to consider Section 3C was right here in the Fifth Circuit, in Voris v. Texas Empire Insurance Association. Importantly, the Fifth Circuit endorsed neither the irresistible impulse standard nor the direct causation test, but said that the decedent in that case could recover regardless of whether either test was applied, and seemed to employ a hybrid analysis. Importantly, the only other court to decide a 903C case was in the District Court of Maryland, which followed Voris and similarly employed a hybrid analysis, adopted neither test, and seemed to come to the same hybrid approach. In the noted case, the Ninth Circuit surveyed federal and state court decisions and ultimately endorsed the chain of causation test as the proper, in its mind, judicial rubric for determining whether suicide-related injuries are compensable under the LHWCA. The court acknowledged that although the irresistible impulse test had once been the prevailing rule among state courts, the direct causation test was now the proper rule and paralleled better with medical experts' opinions regarding the causes for suicide-related injuries under the LHWCA. The court's analysis logically progressed, therefore, to conclude that An analysis of whether a suicide was committed in a delirium or frenzy within the irresistible impulse language had no place in deciding whether compensation was proper. Analytically, if the plain language of the suicide provision must be disregarded, the irresistible impulse test represents a judicial rubric with more entrenched precedential backing. Furthermore, the association between PTSD and attempted suicide is recognized by medical experts and epidemiologists more now than ever before, which indicates the increased need for a test like the irresistible impulse test, which identifies coextensive factors. With that, I'll bifurcate the analysis of Kealoha into legal precedent, medical precedent, and then touch on some of the practical aspects the Kealoha court's decision could have on other federal circuits moving forward. The legal precedent. Although the Boris Court refrained from endorsing a test, the court's ultimate holding is conceptually grounded in the principle that the claimant's psychiatric state at the time of his injury or suicide made it involuntary. This state of mind-based inquiry seems improper, though, in leaning towards the direct causation analysis, as the state of mind would clearly seem to endorse an irresistible impulse standard. Traynor creates a bigger rift, though, in the court's analysis, as the Traynor court found that Longshoreman possessed a viable claim because his mental state made him unable to develop the willfulness to kill himself. So while the court relied on Traynor in its conclusion that courts were trending toward the adoption of the direct causation test, a closer analysis supports a different conclusion. The medical precedent. Suicide is directly linked to PTSD, a prevalent mental health problem that elevates the risk of suicidal behavior. Epidemiologic studies also recognize that traumatic events are directly linked to the onset of suicidal conduct and traumatic events. Longshoreman's work regularly exposes them in a predisposed way to these traumatic events on the job, which will then lead to PTSD and subsequent attempted suicide attempts. The irresistible impulse test, therefore, appears to compose the very criterion medical experts rely on most in evaluating the connection between a traumatic event, the resulting mental effects, including PTSD, and an attempted suicide. The practical effects. Section 903C used to create a bar and was an employer's friend in barring LHWCA claims based on willful intent. But under the Kealoha decision, seems to create another avenue for recovery for longshoremen. Presumably, this will increase insurance rates and liability, which will be spread across the insurance market and be felt by marine employers who may not even employ longshoremen. In conclusion, the Kealoha decision propagates an analytical framework that invites attenuated suicide claims in a period marked by increased suicide rates and enhanced acceptance of mental illnesses like PTSD. Both legal and medical theory mandate the application of the irresistible impulse test, a test that properly evaluates the willfulness of a claimant's suicide attempt and either proper or improper recovery under the LHWCA. Thank you.
Hello everyone, thank you for joining us this evening. I'm Claire Galley, a second-year student in the civil law track at Tulane Law and a junior member of the Tulane Maritime Law Journal. I also have my bachelor's in political science from Tulane undergrad, and I'm a native Louisianian. I'm from DeQuincy. So my case note focuses on one legal development that came in the aftermath of a major maritime event that shook the economy and environment of my home region, and that was the BP oil spill. As many of you are no doubt well aware, as all of you are no doubt well aware, on April 20th of 2010, Transocean's Deepwater Horizon, a mobile offshore drilling unit, or MODU, was drilling the Macondo oil well in the Gulf of Mexico when a blowout, explosion, and fire occurred. 11 people lost their lives and significant amounts of hazardous substances entered the surrounding water and air. The Chemical Safety and Hazard Investigation Board, or CSB, was one of several government agencies to respond and investigate the incident. In the process, the CSB issued 5 administrative subpoenas to Transocean, seeking relevant records and answers to interrogatories. Transocean refused to comply and asserted that the CSB lacked authority to investigate the maritime disaster because the accident was a marine oil spill that did not occur on a stationary source. District Court Judge Rosenthal held in favor of the CSB, and Transocean appealed. The Fifth Circuit held that because the Deepwater Horizon MODU was a stationary source for purposes of the Clean Air Act, the CSB did have the authority to investigate the unit, notwithstanding the Clean Air Act's provision granting the NTSB authority to investigate marine oil spills. To analyze this decision, I first turned to the relevant historical background, and I'll briefly touch on that now. The 1990 Clean Air Act amendments created the Chemical Safety Board, or CSB, and this five-member independent federal agency is charged with investigating serious accidental hazardous air pollution, giving recommendations to prevent and minimize the after effects from such occurrences, and setting out regulations for reporting in their aftermath. The CSB started operating in 1998, investigating and reporting on emissions that stem from stationary sources. The term stationary source actually predates the CSB and is found throughout the language of the Clean Air Act. The Supreme Court has noted the lack of legislative history clarifying the specific meaning of this term in the absence of a narrowed and tailored definition within the statute. However, courts have held that factories, incinerators, power plants, gas sale outlets, and refineries are all stationary sources. Whether or not an entity qualifies as a vessel is a threshold question for the application of general maritime law. Courts have consistently held that structures used in oil drilling operations offshore, including MODUs, are vessels under general maritime law. And the Fifth Circuit categorized the Deepwater Horizon MODU itself as a vessel in the case in Deepwater Horizon. With this background in mind, I'll now turn to the court's decision and lay out the major components of the logic in this noted case. Writing for the majority, Judge Reevely explained that the decision to enforce the administrative subpoenas turned on whether they fell within the CSB's statutory authority. Under the relevant portion of the Clean Air Act, the CSB is authorized to investigate on any accidental release resulting in a fatality, serious injury, or substantial property damages. Accidental release is defined as an unanticipated emission of a regulated substance or other extremely hazardous substance into the ambient air from a stationary source. The Act goes on to define a stationary source as any buildings, structures, equipment, installations, or substance-emitting stationary activities which belong to the same industrial group, are located on one or more contiguous properties, are under the control of the same person, and from which an accidental release may occur. Transocean made the argument that a stationary source should be understood under its plain meaning to encompass non-moving entities only. But the Fifth Circuit dismissed this proposed definition and instead focused on the language within the Act. The court emphasized the Deepwater Horizon was stabilized to be largely stationary over the well for purposes of drilling, which it found was a stationary activity. To underscore its decision, the court noted that the Deepwater Horizon had been physically connected to the seabed in the same location for 2 months leading up to the accident. Next, the court went on to address Transocean's argument that Congress had specifically denied the CSB the authority to investigate accidents of this sort that took place on the well because the Act authorizes the NTSB and not the CSB to investigate marine oil spills. The court rejected this argument also and reiterated the district court's reasoning that the CSB properly investigated the emission of gases and the explosion that preceded the oil spill rather than the spill itself. Judge Reevely found that certain language in the Act indicates that some marine oil spills, including this one, are neither transportation related nor under the exclusive jurisdiction of the National Transportation and Safety Board. In a 12-page dissent replete with very colorful language, Judge Jones outlined her commonsensical reasoning and conclusions. She first distinguished vessels capable of transportation from buildings, structures, equipment, and installations, and asserted that a vessel is mobile and not stationary by nature. She then expressed concern that the majority's holding would cause overly fact-specific determinations of CSB jurisdiction into the future, and she compared the Deepwater Horizon, a vessel effectively treading water at the well site, to a helicopter hovering in place over the ground, in order to emphasize that, in her view, this categorization of the vessel as a stationary source was just absurd. Further, she posited that the majority's reasoning, if applied to an accidental emission from a temporarily moored vehicle, vessel, or aircraft, could result in complete overlap between the CSB and NTSB authority. With respect to the majority's interpretation of the statute's marine oil spill exclusion, Judge Jones reasoned that the Deepwater Horizon incident was transportation related because it involved movement of hydrocarbon from one location to another. At this point, I'll give a short summary and overview of my analysis. At first wash, the layman's reading of this opinion favors Judge Jones' dissent. It seems counterintuitive for the court to categorize a MODU as both a vessel and a stationary source. However, there's no evidence to indicate whether Congress intended for stationary to be read to mean that a qualifying source must be notionally stationary in terms of its purpose, or simply stationary in terms of its physical state at the time of the accident. While it may take some time for the phrase, a vessel may also be a stationary source, to roll off the tongue comfortably, the court's holding on this issue will not cause significant confusion or inconsistency in the law. The legal analyses of vessel status and stationary source status won't overlap, as they stem from separate bodies of law and serve separate purposes. In my opinion, Judge Jones gave a better founded criticism of the majority's decision when she discussed the mechanics of the Deepwater Horizon's dynamic positioning system. The name of the system itself reveals the motion inherent in its use. A ship employing such a system is being constantly repositioned so as to remain in the same selected location. Technically, the Deepwater Horizon was stable, but it wasn't stationary on the water. However, the majority was right to hone in on the perpetuity of the Deepwater Horizon's state of extremely limited motion. Neither a person treading water nor a helicopter hovering over the ground could have maintained its state for the 2 months that the Deepwater Horizon had been operating at the exact same coordinates on the outer continental shelf. While the Deepwater Horizon was not stationary in the same straightforward way a traditional stationary source is, it did pose an environmental threat similar to that of, for example, a power plant explosion, by virtue of its ongoing presence in a single location and the sheer magnitude of air pollution that it emitted. The majority's decision was also made with an eye toward environmental policy and prevented a potential gap in federal regulation following major environmental disasters. The NTSB could not be authorized to investigate this disaster because it occurred beyond the geographical limits of the NTSB's authority, it didn't involve a U.S. flagged vessel, and in the view of the courts, it was not transportation related. Had the Fifth Circuit majority not found that the CSB was authorized to investigate, then there could have been a gap in federal regulatory leadership and direction in the aftermath of this major disaster. In practice, this holding sets a higher standard for disaster response in the maritime industry, as actors must account for a new level of post-disaster scrutiny and regulation. But of equal or greater significance is the impact this decision stands to have outside the maritime industry. Under the majority's reasoning, many vehicles for transportation could fall within the reach of the CSB in the event that an accident occurs while they're stopped. For example, a parked car or a still train that ignites and then releases harmful substances into the air could technically come under the CSB authority, even if the incident did not qualify as transportation related or catastrophic in the view of the NTSB. The legislature should take action to ensure that post-disaster regulatory schemes, however limited or extensive, are clear and easily anticipated. Congress could strike a better balance between mitigating air pollution hazards and providing a stable and predictable regulatory framework for industry actors by revisiting the language of the Clean Air Act and clarifying whether emission sources should be analyzed for their stationary source categorization in regard to their purpose and their notional nature, or their mobile or non-mobile physical status at the time of an emission. Hazardous emissions into the air occur in a vast range of scenarios, but really are a pressing and immediate threat to the public only in extreme cases. And Congress should account for this and limit the CSB's authority and use of resources to those disasters where truly appropriate and necessary. In conclusion, the mission of the Clean Air Act and the magnitude of harm threatened by the air pollutants released during the Deepwater Horizon accident do justify the Fifth Circuit's analysis of the MODU as a stationary source under the authority of the CSB. The decision, however, does not cause meaningful conflict with principles of general maritime law. It does position the CSB for much broader authority over transportation vehicles, and in addition, it causes uncertainty and challenge for industry actors preparing for the worst. This holding shifts the federal environmental regulatory framework and invites Congress to respond to that change with clearer direction and prudent limitations that are for now sorely lacking. Thanks.
Hello everyone, my name is Michael Gaines. I'm a 2L and a junior member of the Tulane Maritime Law Journal. I chose to write about a case out of the Second Circuit, Domico Drive Limited v. Primera Maritime Hellas Limited, because of the potential precedential effect it has, or it may have, on the jurisdiction of the federal maritime courts.
and in particular in determining what falls within that jurisdiction regarding the enforcement of foreign judgments. The facts of this case were fairly straightforward. Dalmaco is an operator of Panamax bulk cargo vessels and entered into a freight forwarding futures agreement with Primera, in which Primera was to pay Dalmaco if the market freight rates for a certain shipping route on certain future dates were lower than a certain price. And on future dates, the rates were lower than that stipulated price, but Primera refused to pay. So Dalmaco sued in the English commercial court, and it sued in the commercial court rather than the Admiralty court because under English law, these freight forwarding futures contracts are not maritime contracts. It was awarded a judgment of over $1.7 million, and again, Primera refused to honor that judgment. So Dalmaco came to the Southern District of New York and sued to enforce that judgment. But however, in the Southern District of New York, Dalmaco asserted Admiralty jurisdiction because under United States law, these freight forwarding futures agreements are maritime contracts. And it's a long-established rule that the Admiralty jurisdiction of the United States courts extends to the enforcement of foreign maritime judgments. However, the district court dismissed Dalmaco's suit on subject matter jurisdiction grounds, essentially determining that English law, not United States law, determined whether the foreign judgment was rendered on the maritime claim. Dalmaco appealed, and hence this case. So there's two components of legal background that are necessary to understand both the court's analysis and then perhaps what I think the court's analysis should have been. The first is the Penhallow rule. And the court kind of frames the main inquiry in this case as what is the proper scope of the Penhallow rule. The Penhallow rule is simply a specific rule granting Admiralty courts jurisdiction over the enforcement of foreign maritime judgments. Admiralty jurisdiction, as we know, has different requirements depending on the type of claim alleged, but at the end of the day, the question is always, does the claim sound in Admiralty, does it have a salty flavor? One rule, though, which I've already mentioned, though, is that the Admiralty jurisdiction extends to the enforcement of foreign maritime judgments. In 1795, in the case of Penhallow v. Doan's Administrators, hence the name of the Penhallow rule, suit was brought to enforce the judgment of what had been the Admiralty Court of Last Resort under the Articles of Confederation. And after that government was dissolved and the Constitution was ratified, the judgment had still not been satisfied, and so the plaintiffs brought suit in the new federal district court to enforce that judgment. And in doing so, they asserted Admiralty jurisdiction. The court enforced the judgment. That was appealed to the Supreme Court. And writing for the Supreme Court, Justices Iredell and Cushing explained that it had been long settled law that Admiralty jurisdiction extends to the enforcement of foreign Admiralty courts. And note the difference in language there, the judgments of foreign Admiralty courts rather than foreign maritime judgments. It was over the 19th and 20th centuries that United States courts kind of explained that language should be changed for understandable, equitable, and policy reasons. Not every nation has Admiralty courts, and not every nation, if it does have Admiralty courts, defines its jurisdiction in the same way. Reaching kind of the high watermark in this line of cases, the Fourth Circuit in Vital v. Primera Shipping in 2013 faced a very similar set of facts in which suit was brought to enforce the judgment of the English Commercial Court. And however, in this case, the suit could have been brought in the Admiralty Court. There was concurrent jurisdiction under English law, but they chose to sue in the Commercial Court. So the Fourth Circuit essentially said, well, substance should trump the form here, and the real question is not whether the judgment came from an Admiralty Court, but whether it was rendered on a maritime claim, or whether the claim was maritime in nature. And it is kind of from that development that the Second Circuit then in Dalmaco kind of saw it a jumping off point, but I'll come back to that in just a second. The second component of legal background references choice of law analyses and the recognition of foreign judgments. The recognition of foreign judgments is governed by principles of comity, which frequently involves determining what law to apply. And this choice of law analysis frequently involves a series of equitable balancing decisions. However, when dealing with a jurisdictional inquiry, it's well established that the law of the local forum must apply. Every state determines which of its courts are competent to hear what types of claims, and that obviates the need for any sort of choice of law analysis. Case in point was a 2013 decision by the Second Circuit in Blue Whale v. Grand China Shipping, in which the district court had applied English law per a provision of the Charter Party to determine whether a prima facie admiralty claim had been pled for purposes of Rule B attachment. And the Second Circuit noted that there was in fact two inquiries involved. The first one was, does the claim sound in admiralty? And the second one is it prima facie valid? And with regards to determining the prima facie validity, foreign substantive law could be applied, but in determining whether the claim sounded in admiralty, only US law could be applied, since it was essentially determining the jurisdiction of the US court. Surprisingly, going to the court's decision in Damaco, as I mentioned, they traced this development of the Penhallow rule to Vital, and essentially saw the next step in the analysis be in determining whether US law or foreign law is used to determine whether the foreign judgment was rendered on a maritime claim. And in deciding that US law correctly applies, they went through essentially a choice of law analysis, noting that there are strong theoretical and practical reasons for choosing US law. One, the definition of admiralty jurisdiction in foreign nations may not be the same. Other nations may not have admiralty courts. Comity favors an expansive in recognition of foreign judgments. It's great to have easy determinations of subject matter jurisdiction. And then surprisingly, only seeing as analogous the idea that jurisdictional and procedural inquiries are controlled by the law of the forum state. The Second Circuit, in my opinion, has come to the right decision, but for the wrong reasons. And while that normally might not be an issue, in this case, the rationale behind the analysis essentially defines how other courts will use this precedent. Had it seen this as simply a jurisdictional inquiry, the law of the local forum would apply, and this kind of jurisprudence is something that is found throughout every other circuit. It's well established that United States law must apply in these situations, and the Second Circuit's even said so in Blue Whale. Instead, having framed it as this novel legal issue, what is the proper scope of the Penhallow rule, the suggestion would be that every court following Damaco would have to engage in its own conflict of laws analysis, and seemingly could be left to decide that foreign law, not United States law, determines the jurisdiction of the US courts. Were that to be the case, the jurisdiction of the court would vary nation by nation, and essentially that would be somewhat of a ridiculous outcome. The Fourth Circuit is the only other court of appeals to have addressed the issue, and it addressed the issue subsequently to Damaco. And though it cited Damaco heavily, it did note that this was in fact a jurisdictional inquiry. But perhaps the most important language from that decision came from the concurring opinion of Judge Wilkinson, in which he stated that it is simply incoherent to speak of adopting foreign law to decide a jurisdictional question. Hopefully the Fourth Circuit's opinion has clarified the legal field, but the Second Circuit is certainly one that is heavily relied upon for maritime issues. So hopefully courts addressing this issue will see the clarity in the Fourth Circuit's opinion and not potentially leave open the minefield that would be using foreign law to determine the jurisdiction of US courts. Thank you.
Good evening, everyone. My name is Alana Riksheim, and I am also a 2L and a junior member of the Tulane Maritime Law Journal. I chose to write my note on yet another maritime case about a train wreck, and this was Sompo Japan Insurance Company of America versus Norfolk Southern Railway out of the Second Circuit. I first came across this case on the News Bulletin of American Maritime Cases, but as newsworthy as it was last year, in fact, it was but the latest installment of over 8 years of litigation. The train derailment giving rise to the legal battle occurred back in the spring of 2006 near Dallas, Texas. And much of the train's cargo, including tractors, automotive parts, and copy machines, was all destroyed. So assigning liability in the wake of the derailment required untangling the international intermodal carriage contracts governing the shipments. The cargo owners had contracted with an NVOCC, or non-vessel operating common carrier, by the name of Nippon Express, to arrange for the through transportation of their goods all the way from Japan to Georgia. Nippon Express engaged the ocean carrier Yang Ming, and Yang Ming subsequently engaged the railroads Norfolk Southern and one of its subsidiaries for stateside rail transportation. Nippon Express and Yang Ming both issued bills of lading, and both of these bills of lading included Himalaya clauses, extending the bill's defenses and liability limitations to subcontractors. The Yang Ming bill of lading, that is the ocean carrier's bill of lading, also included a clause that one might style an exoneration or covenant not to sue clause, which stated that no downstream entity could be liable with respect to the goods transportation other than Yang Ming itself. Now, initially, the cargo interests, or rather their subrogated insurers, attempted to pursue litigation under the framework of the Carmack Amendment. But that entire approach was invalidated when the Supreme Court handed down Regal Bellois in 2010. So a new wave of litigation began, this time focusing on the subrogate's contract, tort, and bailment theories of liability. The railroads raised an entirely new defense at this stage, and they said that the Yang Ming exoneration clause entirely shielded them from suit because it required that all suits be brought against Yang Ming, the ocean carrier. Before addressing the Second Circuit's disposition of these issues, I'll touch on another case that was central to the Second Circuit's reasoning and indeed to my own analysis. That's the Supreme Court decision in Norfolk Southern Railway versus James N. Kirby Party Limited. That case heralded a new era of Himalaya Clause jurisprudence by relaxing the need for specification in Himalaya clauses. So broader, more general language could suffice to pass on the defenses and liability limitations. But the court also considered whether the shipper could be bound by lower liability limitations contained in an ocean carrier's bill of lading, a contract to which it was not party, a contract which it had never seen. The Supreme Court found that this was permissible and expansively held that an intermediary does bind the cargo owner to liability limitations it negotiates on its behalf. So the court agreed to treat the freight forwarder in that case as the shipper's agent for the limited purpose of contracting with subsequent carriers for limitation on liability. Notwithstanding the Kirby Court's more liberal interpretation of Himalaya clauses, there have been other means devised in terms of protecting downstream subcontractors. Recently, negligent third parties have sought the judicial enforcement of covenants not to sue, or exoneration clause, which purport to wholly shield third parties from litigation, and generally by requiring that suits be brought against the issuing carrier. Exoneration clauses are enjoying somewhat of a heyday now. Courts have traditionally frowned on them in U.S. courts rather, because for the fear that they induce negligence on the part of carriage subcontractors. However, my case note cites to a decision out of the Ninth Circuit and a number of circuit courts that have found exoneration clauses enforceable. And in the noted case, the Sampo Court joined their ranks. The court unanimously ruled that the Yang Ming exoneration clause did not violate public policy, and the Second Circuit also held that under Kirby, the NVOCC, Nippon Express, had the authority as a limited agent to bind the cargo owners to the exoneration clause, notwithstanding the fact that this clause basically eliminated the opportunity to pursue the offending railroads directly. Initially, I was persuaded by the court's logic, and chiefly the Sampo Court reasoned that the Yang Ming exoneration clause was just an ordering mechanism, or performed a channeling function, such that all suits had to be brought against the ocean carrier. And the railroads technically remain on the hook for their negligence. It's merely that Yang Ming must sue them. Upon visiting with Professor Force, however, I soon realized the error of my ways, and I became convinced that the Sampo Court had engaged in too broad a reading of Kirby. limitation of liability is not the same thing as exoneration from liability. Consider that in Kirby, which involved only a liability limitation provision, the shipper could sue the intermediary for any loss that exceeded the limitation to which it had agreed. And so this is a concrete dollar amount in damages. And indeed, the shipper in Kirby pursued that remedy. In an exoneration scenario, though, the shipper has the right to sue the ocean carrier, but if it was trying to pursue the intermediary that had signed it up for this channeling of suit, there's the problem of quantifying as damages that prejudice. And the prejudice was very real in this case because in order to pursue Yang Ming, the parties would have to pursue discovery in Texas, then go to a London-based arbitral panel, and finally attempt to enforce that decision in Taiwan. That's real prejudice, but it's hard to quantify. So the Sampo court thus very hastily equated gaps between per package limitations on liability and gaps between entities amenable to suit. There's also the problem of inducing negligence, which I think one cannot escape. Although under the Second Circuit's ruling, downstream actors theoretically remain liable for their negligence, it's those burdensome litigation costs that may effectively let offending subcontractors off the hook. The railroads will never have to answer for their negligence if suit's not brought against Yang Ming in the first place. The efficacy of modern intermodal carriage transportation does depend on consistent, predictable resolution of all disputes, including those that only touch on a land-based portion of their transportation. And in this sense, a downstream covenant not to sue has sort of an intuitive appeal, serving to regulate who will be responsible to whom. However, nothing in Kirby suggests that a cargo intermediary has the authority to extend or to curtail the shipper's right to sue. So I think it is Kirby and not Sampo which strikes the appropriate balance between predictability and equity, ensuring that intermediaries can negotiate reliable downstream contracts while preserving the rights and expectations of shippers who make the efficient choice to ship pursuant to through bills of lading. As a result of Sampo, though, do expect further circuit courts encountering the question of downstream exoneration clause enforceability. Thank you.
Good evening. My name is Clayton Vinioki. I am a 2L and junior member on the Tulane Maritime Law Journal. Tonight I will be discussing Case 19 under the International Tribunal for the Law of the Sea, discussing the arrest of the MV Virginia G and Guinea-Bissau's EEZ for the repeated practice of fishing-related activities. The MV Virginia G, a Panamanian-flagged oil tanker, after supplying a number of fishing vessels with fuel in Guinea-Bissau's EEZ, was arrested for the repeated practice of fishing-related activities. The Virginia G was contracted by the vessel owner of a Mauritanian-flagged fishing fleet to supply a number of its vessels with fuel. In accordance with state law, those vessels received authorization to both fish in Guinea-Bissau's EEZ and to receive fuel from the Virginia G. After refueling two of these vessels that were authorized to be there, and while en route to a third vessel 60 miles off the coast of Guinea-Bissau, the Virginia G was approached by speedboats and boarded by agents of Guinea-Bissau. The Virginia G, its gear, and its product were arrested for violation of State Decree Law 6A 2000. The unauthorized sale of fuel to fishing vessels in Guinea-Bissau's EEZ. Following a volley of unsuccessful court proceedings in the Guinea-Bissau court system, seeking the Virginia G's release, the Virginia G was instead released on the National Day of Spain as a political gesture to the vessel owners. Panama, as the flag state, left without remedy in the Bissau court system, brought the case before an Annex 7 arbitral tribunal, where it was decided by special agreement with Guinea-Bissau to institute proceedings before the International Tribunal for the Law of the Sea. Panama claimed that Guinea-Bissau had violated its right to freedom of navigation under Article 58.1 of the UN Convention for the Law of the Sea, The International Tribunal for the Law of the Sea held that Guinea-Bissau actions did not violate the right to freedom of navigation because the bunkering of foreign vessels engaged in fishing in the EEZ is an activity that may be regulated by the coastal state. What is the EEZ? Today, under the convention, the EEZ is defined as a zone that a coastal state may claim beyond and adjacent to the territorial sea, not extending beyond 200 nautical miles from the baseline to which its territorial sea is measured, within which the coastal state enjoys sovereign rights for the purpose of managing and conserving natural resources, and other states enjoy the freedom of navigation. The idea of the EEZ is relatively modern, stemming from two documents released at the conclusion of World War II by President Truman. These documents, referred to as the Truman Proclamations, laid claim to various areas of the high seas in the name of conservation and development, while specifically preserving the freedom of navigation. Following suit, a number of other countries made similar proclamations, primarily Latin American countries and African countries. However, these latter claims did not reserve the right to free and unimpeded navigation, in effect claiming sovereignty over the high seas equal to that of their land right. These conflicting claims led to a great deal of contention between the states. States with large maritime fleets were interested in preserving the maximum amount of freedom of navigation for their merchant fleets and warships, while developing states, interested in protecting their resources from exploitation by developing states, sought to expand their territorial sea. Today, Part 5 of the UN Convention on the Law of the Sea rectifies these claims by what was seen as an acceptable compromise by defining this zone as a zone wherein the coastal state enjoys exclusive rights to natural resources and other states the right to freedom of navigation. The International Tribunal for the Law of the Sea's analysis. The tribunal's holding was primarily focused on Article 62, Paragraph 4 of the UN Convention for the Law of the Sea. Article 62.4 provides 11 separate categories, each containing multiple examples of fishing-related activities that may be regulated by the coastal state in the EEZ in the name of conservation and management. For example, subparagraph A, the licensing of fishermen, fishing vessels, and equipment, and so on. The tribunal cited a decision in the arbitral tribunal discussing the filleting of fish within the Gulf of St. Lawrence when it noted that the list provided in Article 64 was not exclusive. To determine what other types of activities may be regulated under the convention, the tribunal set out a direct connection test, where it held that, under this test, the tribunal held that fueling of fishing vessels had a direct connection to fishing because it allowed those vessels to stay on station longer without coming into port. In its reasoning, the tribunal cited 7 bilateral and multilateral agreements, primarily the Port State Measures Agreement of 2009 and the Sub-Regional Fisheries Convention of 2012, both of which define fishing and fishing-related activities as including fueling and supporting fishing activities. This holding is flawed for 2 main reasons. First, the tribunal violated customary international law by using various multilateral agreements to impose obligations upon third states. Those agreements are standalone agreements, separate from the convention, and are not binding in this case. Article 34 of the Vienna Convention on the Law of Treaties provides that a treaty does not create obligations or rights for third states without consent. Here, there was no such consent. Secondly, even if Panama and Guinea-Bissau were parties to these agreements, it was inappropriate to use them to define fishing-related activities in the EEZ under Article 62. The tribunal's confusion lies in the motivation for the formation of the agreements relied upon. Article 117 and 118 of the convention provide all states have a duty to take or to cooperate with other states in taking such measures for their respective nationals as may be necessary for conservation of living resources on the high seas. And states shall cooperate with each other in the conservation and management of living resources in areas of the high seas. 117 and 118 create the foundation for the 1995 Fish Stocks Agreement, a standalone agreement under which these 7 multilateral agreements are based. However, 117 and 118 are a different nature than Article 62. As it can be seen from each of the agreements relied upon, these agreements cover areas of the high seas and not the EEZ. Furthermore, they only apply to illegal, unreported, and unauthorized fishing activities, which are not present in this case. Therefore, those conventions should not have been used to define the defined provisions under Article 62 or this case, because both deal with the EEZ and not the high seas. Each of these agreements relied upon by the tribunal are entered into by states voluntarily, and there is no international convention preventing states from implementing robust legislation through regional and sub-regional agreements, particularly with other states. However, that was not the case here, particularly in areas not covered by such agreements. In conclusion, the International Tribunal for the Law of the Sea, sometimes referred to ITLAS because of its questionable and limited jurisprudence, signaled a major departure from international norms by holding in the noted case, from its holding in the noted case to the detriment to the freedom of navigation. The EEZ contains nearly 90% of presently commercially exploitable fish stocks and submarine oil deposits are natural resources. Although the United States is not party to the convention, because the U.S. fleet consists of but a fraction of the world's overall fleet, the delimitation of the maritime jurisdiction in the EEZ under the convention has immediate significance to vessel operators in the U.S. and around the world. Under the tribunal's holding, all secondary fleets operating in the EEZ for the exploitation of resources would fall under the jurisdiction of the coastal state. That power is not granted under the convention, and it is in opposition to the freedom of navigation in which it was created to protect. The tribunal has in effect created law rather than interpreted it. Only through diplomatic protest may the views of the tribunal be challenged. For a more in-depth analysis, please refer to my case note. Thank you.
Well, as Brian said in the beginning, this is our fourth installment of the presentation of student work by the Tulane Maritime Law Journal, and I'm proud to say it's grown very well. I mean, you can see all the people in the room today. And after this is done, we record the video, upload it to YouTube, and the three previous iterations of this have generated over 1,500 hits. So it's been watched, you know, over 1,500 times, and that's way more time than the student speakers have family members and things like that. So there's a lot of people watching. You guys are putting out a really good product, and I'm very proud to be a part of it. So thank you very much, and please join me for a drink.